opposing counsel, and members of the jury. This is a case about a mother who was pushed to the edge and her daughter took the fall. Jordan Ryder was recently released from prison and reunited with her 12-year-old daughter, Parker Page. They took a hiking trip where Parker was pushed over, causing her to fall to her death. This case really began when Jordan was released from prison. She was excited to reunite with her daughter, to rebond, reconnect, make up for lost time. On July 14, 2018, she took Parker to Calkins Campground on a carefully planned camping and hiking trip. Before they went, they stopped for food at a cafe, and they stopped at the big tackle shop for supplies. Jordan knew that Parker suffered from brittle bone disease, making her highly susceptible to falls and injuries, yet decided the two should go on the most complex hike at this campground, the Leckrone Loop. While they were there, the two argued. Parker complained. She asked to leave the hike, and in rage, Jordan pushed Parker over the edge. She couldn't handle how Parker had changed and the comments Parker was making to her about wishing that they weren't together. We, the state, have the burden of proof in this case. We must prove that Jordan knowingly caused the death of Parker. We must prove this beyond a reasonable doubt. I, Alyssa Cookett, along with Mike Schmidt and Lane Wicklund, will prove with our three witnesses. Our first witness is Dr. Quincy. Dr. Quincy will testify as to the autopsy she performed on Parker, about the time of death she found, and about other causes of death from her external and internal examinations of the body. Next, we will call Detective Chesney. Detective Chesney had an investigation on the case of Jordan Ryder. When he first arrived to the scene, Jordan was peacefully asleep in her tent while her daughter was dead at the bottom of the ravine. He also found an incriminating napkin about a life insurance policy that Jordan took out the morning her daughter was dead, after she was gone. Next, we will call Cameron Lee. Cameron Lee was a hiker on the trails. She had many encounters with the pair, saw them arguing, saw Parker limping, and never saw Parker exit the trails with Jordan. After hearing the evidence from these three witnesses, we, the state, ask that you find the defendant, Jordan Ryder, guilty of aggravated murder.
Defense open now. May proceed. Your Honor, opposing counsel, members of the jury, may it please the court. They have accusations, but they do not have answers. The prosecution is bringing charges against my client Jordan Ryder to the tune of aggravated murder against their own daughter, Parker Page. But the prosecution won't even be able to tell you how Parker died, or even definitively when Parker Page died. Jordan Ryder was a single mother who was in prison for quite some time. During this prison, it took a toll on her. The only thing to get her through prison was her own daughter, Parker Page. So when she finally got the chance to go on a hiking trip and bond with her daughter, Parker Page, she suggested Calkins Campgrounds to get some alone time and spend some time together. So they went to Calkins Campgrounds, where they hiked the Wagner Loop and moved on to the Leckrone Loop. However, the Leckrone Loop proved too difficult, and they had to turn back. When they returned to their campsite, Jordan Ryder had let Parker Page go take pictures of the sunset. Unfortunately, this would be the last time Jordan would see Parker alive. Parker never returned from taking pictures of the sunset. Jordan Ryder started searching frantically for her daughter. She searched everywhere, but fortunately for Jordan, Parker never showed. Jordan Ryder never even found out that Parker Page had died until she was arrested in the back of a cop car and heard it over a speaker. Now, the prosecution has the burden of proof in today's case. They must prove to you that Jordan Ryder committed aggravated murder beyond a reasonable doubt. This is the highest burden in our entire judicial system. They must prove the definition of aggravated murder, which is that Jordan Ryder knowingly caused the death of somebody under the age of 13. Now, it has already been stipulated in this case that Parker Page was 12 at the time of her death. But they must also prove knowingly that Jordan Ryder, which has two parts, that Jordan Ryder could foreseeably be certain that the actions they were taking would lead to this consequence, and that Jordan Ryder was taking these actions with full knowledge that they were doing them. Finally, next they must prove causation, that Jordan Ryder actually kicked off the chain of events that led to her own daughter's death. Now, we're going to call 3 witnesses. The first will be Armani Rodriguez. Armani is the owner of Calkins Campgrounds and will testify as to Calkins Campgrounds and also their own interactions with Jordan and Parker. Next, we're going to call Dr. Lopez, an expert in a rare bone disease that Parker Page was suffering from. And they will tell you that there's no definitive way to know how Parker died or when she died. Finally, we're going to call Jordan Ryder themselves to give you the full story on what happened at Calkins Campgrounds that day. Now, they have accusations, but they do not have answers. At the end of today's trial, my co-counsel, Mr. Jordan Weeks, is going to come before you and ask you to remember that phrase and ask that you find Jordan Ryder not guilty of aggravated murder. Thank you.
Any witnesses from the state? The state would like to call Dr. Quincy to the stand. Okay. Can you please state your name for the court?
Dr. Rachel Quincy.
And what is your current occupation?
I work in the office of Chief Medical Examiner as Chief Medical Examiner.
Have you prepared a curriculum vitae?
Yes, I have.
Approaching opposing counsel for the mark is Exhibit 20. Approaching the witness for opposing mark is Exhibit 20. So could I just hand you a copy of?
My curriculum vitae.
And is this a fair and accurate copy?
Yes, it is.
Has it been changed in any way?
No.
I'd ask that Exhibit 20 be added into evidence. Any objection?
No objection, Your Honor.
So, what schooling have you completed for the Dr. MS?
I got my bachelor's from the Ohio State University in biomedical science, and I got my MD from the Virginia School of Medicine.
And do you have any previous work experience?
Yes, I worked in hospitals for 12 years. I started my own consulting firm called Quincy Consulting Incorporated, where I worked as the chief consultant for 3 years. And then I worked in my current job as the chief medical examiner, as the deputy chief medical examiner, before I became the chief medical examiner that I currently hold.
And do you have any licenses or certifications?
Yes, I have my license for Midlands. I was board certified in pediatrics in 1999 and anatomic pathology in 2008 and forensic pathology in 2009.
May I approach the witness in the bench to tender evidence? May. So, what do you do as the chief medical examiner?
I perform autopsies to determine the cause of my subject's death.
Are you familiar with Parker Page?
Yes, I am.
Why?
She was brought into my office for an autopsy.
And when was she brought to your office?
July 14th, 2018, around 4:05 p.m.
And you said you perform autopsies. What procedures do you follow for an autopsy?
I use the subject's previous medical history along with internal and external examinations to determine the time and cause of death.
Are these procedures reasonably relied upon in your field?
Yes, they are.
And did you follow these procedures for Parker Page?
Yes, I did.
Okay. What facts and data were you provided previous to your autopsy?
I was provided the subject's previous medical history.
And was this sufficient information for your autopsy?
Yes, it was.
So you said you performed an autopsy on Parker. Can you tell us what you found from your external examination of her body?
From the external examination, the subject had severe ecchymosis on the right side of her body, measuring 2.25 centimeters in length and about 1.125 centimeters in width, along with several abrasions.
And
Objection, Your Honor. Improper evidence from an expert witness. It has been established that Dr. Quincy is an expert witness as far as being a chief medical examiner is, but we have had no foundation being laid as to whether they know anything about the bone disease osteogenesis imperfecta. We don't know how it affects the body, and I believe that for this to continue this line of questioning, I just ask that the foundation be properly laid.
I missed what it is that she said, because I was taking notes. What did she say?
They started talking about the osteogenesis imperfecta and the bruising that could happen because of that. It hasn't been found, there has been no foundation laid as to how she knows about this particular bone disease and how it would affect the body.
Response?
we were talking about how the bruising relates to osteogenesis imperfecta, but I can lay a little foundation for how she would be aware of that.
Go ahead and lay it.
Have you ever learned about osteogenesis imperfecta in schooling or other jobs?
Yes. It causes severe bruising and breathing problems and it causes their bones to break more easily.
Have you had patients in the past that have had this issue?
No.
So, but you have learned about it or seen it before?
Yes.
So, what did you find from the internal examination of your autopsy?
From the internal examination, there were several fractured bones as well as a fractured skull. Her head, chest, and legs, as well as her right ankle and right knee. And yeah,
Did you determine a time of death from this autopsy?
yes.
And how did you determine this time of death?
I used the method widely accepted in forensic pathology, which takes the subject's body temperature minus the liver temperature divided by 1.5 to determine the time of death.
And what time of death did you find from your examination?
The subject's death occurred approximately 19 to 21 hours prior to the examination, so that would be about 4 to 6 p.m. on the 14th of July, 2018.
And did you do any other things with this case?
Yes, I spoke with Detective Chesney.
And what happened when you spoke with Detective Chesney?
He asked me to identify some items that he brought to me to see if they were consistent with the bruising on Parker's body.
And did any of the items he showed you match the description you were looking for?
Yes,
What item would that be?
the hiking staff he showed me.
And if I showed you a picture of this hiking staff today, would you recognize it?
Yes, I would.
Approaching opposing counsel with West Markets Exhibit 17A. Approaching the witness with West Markets 17A. Okay. What did I just hand you a picture of?
The hiking staff.
And what did this hiking staff show you from your autopsy and your meeting with Detective Chesney?
So what this hiking staff showed me was it has a capped end right here that measures 2.25 centimeters in length and 1.125 centimeters in width, which is consistent with the bruising on Parker's body.
approach the witness and the bench to tender evidence.
Would you like to offer it first?
I'd like to ask that exhibit 20, exhibit 17A, evidence evidence.
No objection this time around?
May I approach the senator? Dr. Quincy, can you tell me what your final conclusions for this case are?
My conclusions based on my autopsy conclude that the subject's death was not caused by environmental or natural reasons, but rather that it was homicidal reasons for death.
No further questions. Ross?
Yes, Your Honor. Good afternoon, Dr. Quincy.
Good afternoon.
You were the medical examiner that dealt with Parker Page's body, correct?
Correct.
And with coming to a medical examiner, to examine the body, you give a cause of death.
That is correct.
In your case, your cause of death was a temporal fracture right in the head, correct? And also in your report, you note that she had a bimolecular fracture right by her right knee,
Yes,
and she had a hairline fracture on her left clavicle.
that is correct.
Now, you going to medical school and understanding how bones work, a hairline fracture is a lot lighter than a bimolecular fracture.
Correct.
It takes a lot less force to create that clavicle to break, correct?
Yes.
There are many different things that can cause a bony area to break, correct?
Mm-hmm.
Like falling, tripping, even running into things.
Correct.
Now, I want to talk about your report. You got some information from Detective Chesney, correct?
Correct.
Originally, in your report, you stated that you could not figure out whether or not it was a homicide or an accidental death, correct?
Correct.
It was only after Detective Chesney sent you those items that you changed your report?
Yes.
And this was 3 days after you examined the body.
Yeah.
And you didn't examine the body a second time, correct?
No.
Based on the items that you got from Detective Chesney, you simply measured up and changed your addendum, correct?
Yes.
Now, finally, Dr. Quincy, you concluded that Parker's death might have been accidental, correct?
No.
You did not rule her death as a possible accidental death upon your first examination of the body.
Sorry. Yes.
And you said yourself that the collarbone only had a hairline fracture, that hairline fractures are easier to break, or the easiest form of fracture, correct?
That is correct.
It takes the least amount of force to break a collarbone for a hairline fracture. Yes?
Yeah.
It can happen, like you said, because of someone falling, because of someone tripping. And now, Parker Page was found at the bottom of a 40-foot cliff, correct?
That is correct.
So it's possible, doctor, that that bruise on her clavicle and that break could have been from her falling. Correct?
Correct.
Thank you. No further questions.
Redirect? No redirect, Your Honor. I just asked them what this be allowed to sit down. Anything else from the state?
Defense would like to call Detective Chesney to the stand. Good afternoon, Detective Chesney.
Good afternoon.
Please state your name for the court and spell the last.
Detective Jacob Chesney, Chesney.
What do you do for a living, Detective Chesney?
I'm a detective in the Lewis Police Department.
And how long have you been a police officer?
I served 8 years as a patrol officer and the last 2 as a detective.
Since becoming a detective, how many cases have you been assigned to?
I've been on 6 cases since I was a detective, all of them being homicide.
Where were you working on July 15, 2018?
Yes, I was actually on duty at home.
Did you receive a call on July 15, 2018?
Yes, I received a complaint that there was a possible kidnapping with the victim being Parker Page and the complainant being Corbin Dallas.
What did you do after receiving the call?
After receiving this call, I went to the complainant's house, Corbin Dallas, and asked him questions while the team looked for any clues as to where Parker maybe canvassed the area, just standard stuff.
And what did Corbin inform you about?
So Corbin told me that he had last seen the complainant on the 13th, 2 days prior, when she went to a movie with Jordan Ryder, her guardian.
Did you learn anything else from Corbin?
I learned that Corbin was actually her legal guardian, and that Parker had brittle bone disease, which meant that her bones broke more easily.
Objection, Your Honor, to an improper opinion. May I explain? Now, opposing counsel, or Detective Chesney is laying foundation about brittle bones disease. However, there's been no evidence laid that Detective Chesney himself is an expert in this, and therefore can't testify to the specifics of Parker Page's illness.
We're not testifying he's an expert in brittle bone disease. We're testifying to the rational based perception of the court conversation he had with Corbin Dallas.
May I respond, Your Honor? Even so, it's not within his rational-based perception to draw conclusions based off of expertise that this witness just simply does not have. And because of that, Your Honor, it's an improper opinion.
You can testify to his rational perception of the conversation. If it goes past that, feel free to re-object.
Yes, Your Honor.
So did he say anything else?
Yes. Besides that, he also stated that he had access to Parker's Find My Phone account, so we used that to track her last known location to Calkins Campground, and whether it had been turned off or died the day before.
And what happened when you arrived at Calkins Campground?
So when we got to Calkins Campground, I met with the owner, Armani Rodriguez, and Jordan, he positively identified Jordan Ryder and Parker Page as having come to the campground.
Did you go and check what they were saying?
Yes. From there, we went to the campsite, which he had rented them, and there I saw Jordan Ryder sleeping in the tent.
What did you do after this?
After this, I woke her up and asked her some questions as to if she knew anything about where Parker could be, upon which she seemed kind of confused and kind of just a little unaware, I guess.
Objection, Your Honor, to speculation. May I explain?
Yes?
This witness is testifying that the defendant was confused and out of it. However, this is not within his rationally based perception because he's delving into the mindset of whether Jordan Ryder was or was not confused and dazed.
He said seemed. However, if you would like, I can rephrase the question.
Rephrase the question.
Yes, Your
Did Jordan Ryder seem? How did Jordan Ryder seem when you talked to her?
So Jordan said that she was not fully aware of where Parker could be, but admitted that there was a very good chance she was in violation of parole. So as standard procedure, we arrested her.
And what did you do?
So after arresting her, I then searched the campground with the permission of Armani, the owner, since it was on his property, upon which I found a hiking staff and his tent.
What did you do after the search?
So after the search, I then released a press release, which was asking the public for help as to any information they had about where Parker could be, or any information that they knew about Parker to help us find where she could be. Upon which I heard from a hiker that also happened to be at the campground, that she had seen them that day, or the day prior to that.
Where did she see her at?
She saw them on Leckrone Loop, which was one of the trails at the campground. It was up on top of a cliff on that loop. She took us there upon contacting us.
What did you find on the trail?
So when she took us there, it was me along with the canine unit and the EMT, and at the top of the trail where she had seen them, the dog indicated towards the edge of the cliff as to Parker's scent had been there. So then we went back down underneath of the cliff and walked to directly underneath of that spot.
What did you do after the canine unit indicated at the cliff?
So upon reaching that spot underneath the cliff, we found Parker's body there, unfortunately.
Can you describe the scene?
It was apparent that Parker was not alive any longer, she was deceased. And so we immediately taped off the scene as to preserve any evidence that could possibly be there.
Did you stay after that?
I briefly stayed and then I was relieved, upon which I went back to the campground.
What did you do after going back to the campground?
So then we went back to the station, and I conducted an interview with Jordan Ryder about a formal interrogation about the events.
What did you find out from the interrogation?
So during the interrogation, I was asking about medical insurance, upon which Jordan Ryder stated that started talking about life insurance and that there had been a policy taken out on Parker.
Approaching opposing counsel with what's marked as Exhibit 25. Permission to approach the witness.
Yes.
Is this a fair and accurate copy of the life insurance policy that you were talking about with Jordan?
Yes, this is the life insurance policy.
Permission to approach the bench to tender evidence.
That's not an evidence yet.
Permission to admit this into evidence.
Any objection?
Yes, Your Honor. The state objects under hearsay. These are statements not made by the party opponent being used for the truth of the matter asserted.
This was admitted by Jordan in his interrogation.
May I respond, Your Honor?
Yes.
Although it's true that Jordan admitted that they filled out this life insurance policy, the policy itself is a statement made by the insurance company and not by Jordan Ryder. And because of that, Your Honor, it's not statements by Jordan Ryder herself.
It is not being made for the truth of the matter asserted. It's used to show that Jordan Ryder attempted to, it shows to Jordan's frame of mind at the time and how her relationship was with her daughter.
Your Honor, this is being used for the truth of the matter asserted. Because this is showing that Jordan Ryder was filling out a life insurance policy, or that the insurance policy got submitted at 3 in the morning, which, if I may make an offer of proof,
You may.
opposing counsel is going to then say that this was when Jordan was looking for her daughter, instead of looking for her. Yeah, she made this at the time when she was searching for her daughter, instead of being on the campground looking for her daughter, Your Honor. This is being used for the truth of the matter asserted.
I was actually not going to go there with my line of questioning. I was actually going to connect it to a further piece of evidence that I will get to at the end of this line of questioning. This lays foundation for the next piece of evidence.
Just as a lays foundation doesn't mean that it's not hearsay, so at this point, we have to sustain the objection.
Okay.
Yes, Your Honor.
Did the amounts shown there mean anything to you?
The amounts that I saw on that policy matched what I had taken from a napkin, which I found as I conducted a standard pat down of Jordan when I arrested her.
Objection, Your Honor, to speculation. May I explain?
Yes.
Detective Chesney is simply Trojan horsing this piece of evidence that was already not admitted by saying that there were similar amounts drawn. Detective Chesney doesn't know what Jordan meant by the statements of $200,000. Because of that, Your Honor, Detective Chesney is speculating.
Response?
He's not speculating. This was that he. I'm sorry. Can you repeat your argument?
Yes, Detective Chesney made several statements about Jordan Ryder writing something regarding $200,000, and it's drawing parallels to that, to the life insurance policy itself. But because we don't know why Jordan wrote those things on the napkin, this is speculation.
It's based on his rational basic perception that because the numbers were the same. It's not being out for the truth of the matter asserted.
May I respond, Your Honor?
Yes.
Whether or not it's being used for the truth of the matter asserted, it's still speculative because Detective Chesney is drawing conclusions based off of parallels of evidence that Ms. Ryder herself only would know. Detective Chesney would need to delve into the mindset of Ms. Ryder in order to determine what those numbers meant and what those amounts meant, and Detective Chesney cannot.
Yeah, based on the arguments, I'm going to sustain the objection. You can ask about this napkin, you have it, and you can get it into evidence, but you can't say, you can't guess.
Okay.
Yes, sir.
You recognize this napkin?
Yes, this is what I found on Jordan, and when I conducted that standard pat down before arresting.
Is it a fair and accurate copy of that napkin?
Yes.
Permission to admit it into evidence?
Any objection?
No objections, Your Honor.
Then,
So what did you do after that?
So after that, I then used that napkin to get a search warrant for Jordan's phone.
What did you find on the phone?
So on the phone, I found a life insurance policy, which had been changed. the night of the death.
Objection to hearsay, Your Honor. May I explain?
Yes.
Again, this life insurance policy cannot be admitted into evidence because this is a statement being made by the life insurance company themselves. Any statements about the life insurance policy or the specifics of it cannot be talked about because those are out-of-court statements being used for the truth of the matter asserted.
No one said anything about submitting it into evidence. It's merely talking about the chronology of what happened that night.
May I respond, Your Honor?
Yes.
Whether or not it's submitted into evidence, if they talk about it, that's still hearsay because the life insurance policy statements are statements by the life insurance company, not by Ms. Ryder.
I'll sustain the objection. You can mention the existence of, but nothing was on it unless it gets to evidence.
Yes, Your Honor.
Do you find anything significant? Was there anything significant about the life insurance policy?
Yes, on the life insurance policy, it appeared to be similar to the napkin.
Objection, Your Honor, to hearsay yet again.
Sustained.
No further questions. May I ask for my copies?
No, he's got to be cross-examined first.
May I set up the welfare use of the demonstrative?
Yes.
And permission for opposing counsel to move if necessary to see the demonstrative?
Absolutely.
Thanks. Would you be able to see it?
Yeah.
Good afternoon.
Yeah.
My name is Jordan, and I'm just going to be asking you a few questions on behalf of Ms. Ryder, okay? I want to start by talking about your role as a detective, okay? You would agree with me that at the start of the investigation, it's very important to stay as impartial as possible, correct?
Yeah, being unbiased is one of the main procedures in standard investigations done by police departments.
Right, you're just looking for the truth, correct?
Yes, we just collect the evidence and then let others interpret it from there.
You don't go around just accusing anybody, right?
No, we try not to draw any conclusions until we have everything possible.
And you certainly don't accuse someone just because they were the easiest suspect, correct?
That is correct.
Now, you mentioned on direct examination that you relied on statements from other witnesses, correct?
Yeah, we collect statements from anyone who could possibly be involved or was around at the time to see if there's any valuable information there.
Now, before we get to the specifics, would you recognize a picture of the Calkins map if I were to show it to you?
Yes.
Permission to approach opposing counsel would be Exhibit 22.
Yes.
Permission to approach the witness with the same.
Yes.
And would Your Honor like a courtesy copy?
Is that what's good about it?
It will be, yeah. No, okay. All right, now I just handed you a map of the Calkins campground, correct?
Yes.
It doesn't look to be changed or altered in any way.
Not that I can tell. No.
This is the same map that you used in your investigation.
Yeah, this is the one that we were provided.
At this time, the defense offers Exhibit 23 into evidence.
Any objection?
No, Your Honor.
Now, Detective Chesney, one of those statements that you took from was from Kelly Deuce, right?
Yes.
And you're aware that Kelly Deuce saw Jordan and Parker at the Overlook around 4:30, correct?
Yeah.
You're aware that Kelly saw them having a discussion, correct?
Yes, she said that she had seen some interaction between them while she was there.
You're also aware that Cameron Lee saw Jordan and Parker around 4:30 on the Legroom Bridge, correct?
Yes, there were multiple people who had seen them throughout the day.
And Armani Rodriguez also saw them around 4:30, somewhere on the Legroom Loop Trail, correct?
Yes, that is correct.
Now, this might sound like a silly question, but you can't be in three places at the same time, right?
Yeah, that is correct.
Were you aware of that in your investigation?
Yes.
So you were aware of this, but you still thought that Jordan Ryder was to be accused?
Yes, they had all seen them on the trail at that point. They had been together. All three witnesses had placed them together on the same trail at the same time. Whether they were a few minutes off or not, I could not know for sure, but knowing that they were together left Jordan as the most probable suspect at that point.
But Detective Chesney, they're not just minutes apart. You would agree with me that this is miles apart, right?
Yeah, there was some distance there.
Now, I want to talk a little bit more about your investigation. Now, after you arrested Jordan, like you said on direct examination, you arrested Jordan in suspicion of a parole violation, correct?
Yeah, that is correct. That's standard procedure. When we know we have a repeat offender who has violated their parole, we have to arrest them so as not to let them get away from us or give them any opportunity to impede our further investigations.
Now, like you said earlier, you're not looking just to accuse anybody, right?
No, we do not want to accuse until we have the facts.
So you saw Jordan at 10 o'clock, right?
Yes, that is correct.
And at 10:09, you arrested Jordan on suspicion of parole violation, correct?
Yes,
You didn't call Jordan's parole officer to see if Jordan in fact was in violation, correct?
no, we did not. We were pretty confident at that point and felt like even if they weren't, then it was still in our best. She was still the most probable suspect at that point also, so those two being combined, we felt like we should arrest her at that point.
Well, at this point, you didn't find Parker Page's body, did you?
No, we did not find the body yet.
So you arrested Jordan after 9 minutes, and then you took Jordan downtown to question Jordan, correct?
Yeah, that is correct.
And in that interrogation, you asked Jordan all about Jordan's parole violation, right?
Yeah, we asked him a little bit, but our main focus was on Parker. That was the bigger situation, I think.
Would you recognize that interrogation if I were to show it to you?
Yes.
Approaching opposing counsel with Exhibit 1. Permission to approach the witness with the same.
You may.
Now, can you point to me where in this interrogation you talked to Jordan at all about their parole violation?
I do not remember where exactly.
Well, Detective Chesney, it's because you didn't ask a single question about Jordan's parole violation after you arrested them.
Like I said, Parker